Is it possible to meaningfully challenge solitary? In this episode, Bobbin, Mark, Julia, and Zach peel back the layers of Oregon's opaque grievance processes, Supreme Court rulings, and procedural roadblocks that leave those incarcerated with almost no recourse to contest their placement in isolation. Tune in as we trace the history, legal hurdles, and ongoing reform efforts aimed at shining a spotlight on and ultimately curbing, abolishing, the use of solitary confinement in Oregon. Coming up next on Trailblazing Justice. This is Trailblazing Justice, episode 66, recorded Thursday, May 22nd, 2025. Solitary Confinement in Oregon, part 3 of 5, Challenging Solitary. It's time for Trailblazing Justice, the weekly podcast where we discuss civil and criminal rights in Oregon and beyond. Trailblazing Justice is a production of the Oregon Justice Resource Center. Here's Bobbin.
Welcome to another episode of Trailblazing Justice. I'm Bobbin Singh, the Executive Director of the Oregon Justice Resource Center. And today I have with me Zach Winston, our Director of Policy and Outreach, and Julia Yoshimoto, the Director of the Women's Justice Project and Senior Advisor to the Oregon Justice Resource Center, our co-hosts. And joining us again is Mark Wilson, Legal Assistant with the Oregon Justice Resource Center. And we're picking up our conversation on solitary. This is Solitary Part 3. You can listen to the previous episodes on our podcast website or any podcast provider that you listen to. Today, we're going to be talking about just how to challenge solitary, or the legal and administrative ways to be able to, for an individual to be able to challenge their placement in solitary. And just to get to the end of the story here, what we'll say, or what we'll be able to show you is once someone is put into solitary, there's very little that that person can do to actually legitimately challenge their placement in solitary. But Mark will help us understand how we got here and how the process works and why we need some additional reforms and oversight of the Department of Corrections and its use of solitary. Mark, you just want to start us off again and remind us of the 3 or 4 different types of sort of official things that we call solitary?
Sure, yeah. I guess it would be disciplinary segregation, administrative segregation, the intensive management unit, which in other states is security housing unit or SHU programs, or there's all kinds of different names for that kind of segregation. Then you have like medical isolation, and there's some other things like that. But the main 3 are probably like your IMUs, your DSUs, and your ADSEGs.
Yeah, and for administrative segregation, as we discussed in our previous podcast, it's almost where people are placed while DOC is doing something, or when there's immediate risks, or something in which they just need to put someone if they're under investigation, they put them in ADSEG. And when we talk about disciplinary seg, that's after typically someone's been found guilty of a sanction. Is that right?
Yes, that's right. Yep.
All right. So when someone is placed in what we call solitary, or these different units that we are defining globally as solitary, there's ways for individuals to challenge their placement in these different solitary units. But the ability to challenge it is tricky. And I know you wanted to start off with some history, just to give us some more global context about how DOC has the power to do this and place individuals, and the limitations that may exist in reviewing that. Do you want to just talk us through? I think there were some Supreme Court decisions that help sort of layer or provide like an overlay on all of this.
Yeah, that would be great. I think that that historical context is really important to this discussion. So in 1890, the United States Supreme Court actually first recognized that solitary confinement is horrible. This is a case called In re Medley, and this was a man that was sentenced to death in Colorado, and there was this new law that required that somebody under a death sentence, even though he was only going to be there for a month before they executed him, would be required to be placed in solitary confinement. And the issue in this case was whether or not that was an acceptable thing for them to do to him. And the Supreme Court in 1890 said this about solitary confinement. It began in America with our first prison, the Walnut Street Penitentiary in Philadelphia in 1787. And then other states kind of followed suit after that. And then they said, but experience demonstrated that there were serious objections to it. A considerable number of prisoners fell after even a short confinement into a semi-fatuous condition from which it was next to impossible to arouse them, and others became violently insane. Others still committed suicide, while those who stood the ordeal better were not generally reformed and in most cases did not recover sufficiently mental activity to be of any subsequent service to the community. It became evident that some changes must be made in the system. This was in 1890, they said this. And in saying that, they said some 30 to 40 years ago, so in 1840 or 1850, the whole subject attracted the general public attention, and its main feature of solitary confinement was found to be too severe. And yet here we are still today, subjecting people to it 175 years later. And the question is why? But the answer is really that the American public decided to get tougher on crime, and the courts responded accordingly. In 1983, there was a man that was subjected to administrative segregation, and this case made it all the way up to the United States Supreme Court as well. This is a case called Hewitt v. Helms. And interestingly, in that case, the Supreme Court said, much like Bobbin was just talking about at administrative segregation, the phrase administrative segregation, as used by the state authorities here, appears to be something of a catch-all. It may be used to protect the prisoner's safety, to protect other prisoners from a particular prisoner, to break up potentially disruptive groups of inmates, or simply to await later classification or transfer. And then they said, this is the horrible thing about this that has had ripple effects through the years. The court said, accordingly, administrative segregation is the sort of confinement that inmates should reasonably anticipate receiving at some point during their incarceration. So that was in 1983. And then fast forward to 1995, we're back in the United States Supreme Court again, but we're also in the height of the tough on crime movement at that time. And this is a Hawaii prisoner who tried to go to federal court to challenge a disciplinary sanction of 30 days that he received and was in disciplinary segregation instead of administrative segregation. And in denying his right to be able to challenge his state disciplinary charge in federal court, the United States Supreme Court created a really horrible test that applies across the nation today. And it is one that requires a prisoner to demonstrate that their confinement in a segregation unit creates what is called an atypical and significant hardship in comparison to their normal conditions of confinement. And in this case in particular, the Supreme Court said, we hold that Connor's discipline in segregated confinement did not present the type of atypical significant deprivation in which a state might conceivably create a liberty interest. The record shows that at the time of Connor's punishment, disciplinary segregation with insignificant exceptions mirrored those conditions imposed upon inmates in administrative segregation and protective custody. Thus, Connor's confinement did not exceed similar but totally discretionary confinement in either duration or degree of restriction. And so that was Sandin v. Connor in 1995. Interestingly, that has, well, since 1995 up to the present day, courts have grappled with what is an atypical and significant hardship. And they've looked at, 30 days in Sandin v. Connor wasn't atypical, but is 6 months or is a year or is indefinite. And, courts have come up with varying decisions on that across the nation. Some courts have said a year is, some courts have said a year isn't. Some courts have said indefinite is, some courts said indefinite isn't. They've also looked at things like what are the conditions of confinement the person is subjected to within the disciplinary segregation unit to determine if it is atypical and significant hardship. And now more recently, they're starting to look at what is the psychological impact on a prisoner in these segregation units. And these are all areas of law that, are constantly at flux, but if you kind of went down and did a survey of all the cases, it would probably be the majority of them are denied rather than granted. The sad thing is that this dealt with state prisoners being able to bring federal challenges to their solitary confinement, but it's also had a negative impact on your ability to bring actions in state court. Mm-hmm. In 1973, the Oregon legislature passed a law, ORS 421-195, that gave prisoners the right to seek judicial review of prison disciplinary orders in the Oregon Court of Appeals. That law remained in effect until the Oregon legislature, again at the height of the tough on crime movement, repealed that law in 1995. And so while I was working in the prison system as a legal assistant between 1987 and 1995, I routinely helped prisoners who were in segregation units file court actions against their disciplinary sanctions, and we prevailed in the Court of Appeals in getting fines reduced or removed, getting people out of segregation units. We were actually even able to use the disciplinary segregation appellate statute that I just mentioned to challenge IMU placements. And in some instances, I was able to get people out of IMU, at least pending the outcome of the appeal. Yeah, go ahead.
Yeah, so let's talk about all this because you've mentioned a lot to us just now. A lot of Supreme Court decisions that I think which highlight the fact that the federal courts aren't really open to reviewing solitary in really a meaningful way and understanding its impact. But we'll get there in just a minute as far as like what the federal courts are really looking at based on Supreme Court decisions. But because these Supreme Court decisions have basically said solitary is permissible, it gives wide latitude for the Department of Corrections and how they think about when they're reviewing from an administrative standpoint the placement of individuals in solitary. So why don't we start there? In one of the episodes, you had talked about physically sort of what happens when you're placed in ADSEG or disciplinary segregation. Can you walk us through that again? But this time through the lens of you're going to challenge it. Like once someone puts you in DSU, what steps are you taking at that point in order to challenge your placement in segregation?
Sure. So typically there are not a lot of ways you can challenge it. In my situation, I was placed in segregation, in my belief, wrongly, and I think we proved that later on. But I intended to challenge it. And that meant I would need to, there aren't really any good avenues to challenge in state court. So I would have needed to challenge in federal court, which is a very difficult thing to do. And so there's things that you have to do in the process when you go into segregation to make sure you're able to do that. Also in 1995, the Congress passed the Prison Litigation Reform Act, the PLRA. And one of the things they did in doing that is they made it harder for prisoners to bring federal challenges about state conditions of confinement and whatnot. But one of the things they did with that was required all prisoners to exhaust all available administrative remedies before they are allowed to come to federal court. And the way that the courts have interpreted that law since then is if there is an available administrative remedy offered by the prison officials and you fail to pursue that, or you make a mistake somewhere along the way in pursuing it and they don't actually resolve your administrative challenge at the prison, you will be barred from going to federal court.
And so,
Yeah, go ahead.
when we talk about administrative challenges, what we're talking about is essentially the processes or procedures that are available within the prison system. So you're not looking to the courts, you're not looking to the legislature, you're not looking to any external body to help vindicate your rights. There's usually through rulemaking, which is DOC creates rules and processes, which is all loosely, not loosely, but there's a Supreme Court precedent in cases that sort of guide like how much process is required, and typically, which is some process, but it's all a creation of the Department of Corrections at this point. You're within sort of the administration or administrative process of the Department of Corrections, and you have to follow those rules. And when the federal courts are saying, in order to be able to preserve your federal court challenges, they have to exhaust administrative remedies. The idea is, you have to try to do everything you can, and the federal courts are a backstop, is the theory. But there's a distinction. There's the available administrative remedies that exist, which we'll talk about, contrasted with, are they actually meaningful remedies? And so I think when I heard the tone in your voice, exhaust administrative remedies, you almost talk about it as, well, this is just like a procedural thing I have to do in order to get into federal courts. It doesn't sound like what you're saying is that you have any faith or confidence in those administrative remedies to actually do anything meaningful, right?
Correct. Even as a legal assistant, I would tell people, and I believe to this day that unless you are planning to go to federal court, there is really no reason for you to file administrative remedies because they're not going to grant you any kind of relief. It's a kangaroo process. It's designed to reinforce the decision that was made against you that you're challenging. And there's no intention. And even when you are exhausting it for the purposes of going to federal court, anything that they do to respond to that is helping themselves, solidify their decision for federal court challenge later themselves, and so there's never any, I mean, I don't know what the number is, but the percentage of administrative challenges that are granted is, virtually non-existent,
Yeah, and kangaroo court's kind of like a good way to put it, because in most instances, like if you are out in the community and let's say criminal charges are pressed against you, you have a public defender, there's a prosecutor, there's a neutral, judiciary that's kind of overseeing it. It's an adversarial process. But within the Department of Corrections and the administrative in the administrative processes that you're going to seek administrative remedies, in this instance, you have the corrections officer who have filed charges against you, sanctioned you. They're effectively like the law enforcement, right? They're also the prosecutors in this case because they're the ones that are bringing evidence against you in the administrative hearings. They're also the judge in the case because it's corrections officers that are overseeing it. And we'll talk about this too. You don't get a right to an attorney. So this is just you representing yourself against the people who have sanctioned you. So there's a clear conflict of interest because there's not any incentive to actually get to what actually happened or to listen to the AIC, because why would there be any incentive to overturn an action the Department of Corrections has done in which you're challenging, in which they're reviewing? I mean, it seems kind of silly, right? To say, oh, never mind, we were wrong. We didn't mean to sanction you. You were right. That kind of thing. But can you
And
walk us. Yeah,
when you say it's you challenging this,
yeah.
I don't want people to think of it as like me as someone who knows what I'm doing challenging it. This is, you know, prisoners who can't read or write. It's prisoners who don't speak English. It's prisoners who have severe mental health issues. They are the ones that are trying to navigate that process without help.
And oftentimes, well, in segregation or solitary.
Absolutely.
Yeah, so walk us through. So, with all those caveats, I mean, you are a legal assistant, you're extremely high functioning and capable. The moment you got placed into DSU, you're beginning to think about, let's just say there is some hope that the administrative process works. What are you doing to prepare at that point? Or how does the administrative process work? How do you get it started?
Okay. So I think before we do that, I have to explain what the administrative processes are, because in
Yeah.
my situation, I used two of them, and both of them failed. But so generally, the Oregon Department of Corrections has a grievance process that is available to all prisoners. It's a three-step process that's really convoluted and one-sided and difficult for people to navigate all through the steps. There's a strict timeline on the prisoner. There's no timeline on the prison officials, that kind of thing. But only certain things can be raised in grievances. Certain things specifically cannot be raised in grievances, and those are things that have their own administrative review process available to them. Disciplinary orders are one of those. Mail violations, visiting violations, placement in IMU, all of these things have their own administrative process that the prisoner has to use within whatever guideline timeframes that the prison officials established for that particular remedy to be utilized. And so, I had a disciplinary hearing on August 31st and was placed in segregation. Now, at that point, you're verbally told by the hearings officer what your sanction is, and you're moved to segregation. But then they do a preliminary order that then goes to the superintendent, who signs off on it. And then the superintendent sends you what's called the final order. And when I say sends you, it's through the institutional mail system. And, when you're in segregation, that means when mail call comes around, a guard comes by and puts a piece of paper on your bars of your cell, and that's the final order. And maybe you'll get that, maybe you won't. And if you don't get that, well, that's going to affect your ability to do an administrative challenge, because the rule requires that you, first of all, use the form that they've created, which is not available to you in the segregation unit. So you have to reach out to the prison law library through the kite system, which again is through the mail, which is guards are controlling what's getting out of your. So when you're in segregation, anything that you want to put in the mail, you can't just go put in the mailbox. You put on the bars of your cell, and when a guard does a tier check, if there's something on the bars, the guard will pick that thing up and ideally drop it in the mailbox at some point. And that's the same coming in. And maybe they do, maybe they don't. If they're, there's been instances where things just disappear, right? But anyway, so when you're in segregation, you've just been found guilty of a disciplinary violation. You need to ask the guard for what's called a kite, an inmate request form. And on that kite, you write the law library and say, I need an administrative review form. Now, there's nothing that tells anybody they need to do this. So it's just one prisoner telling another prisoner, hey, if you want to challenge this, you better get a kite and write the library and tell them you need the form. And there's a timeline for you doing this. And so in that case, you have 60 days from the date of the superintendent signing the disciplinary order for you to submit an administrative review request to the Inspector General at the Department of Corrections.
So just to be clear, when someone's placed in disciplinary seg, there's no type of information provided to that AIC about what their rights are, how they can challenge it, or how they can access this form.
Not that I can recall, no.
And if you do have like special needs or some sort of some sort of deficits as it relates to like either intellectual deficits or cognitive capabilities, ADA kind of requirements, do people get any type of support or help?
No, no. Perhaps somebody in the cell next to you can help you write something and then put it under the bars, and you can reach out and try to get it and pull it back into your cell. And but yeah, no, you're not getting any assistance if you have a disability of some type that impacts your ability to do that.
So basically, you're placed in this, and unless you know, or someone is able to share that information with you about how you can challenge it, there's no way you just wouldn't know, right?
Correct.
Yeah. So for you have to write the law library, you have to get this form, and
So
then
hopefully that whole process works and you actually succeed in getting a blank administrative review form to your cell. If you don't and you try to do an administrative review form on your own, they will reject it. They will say you didn't use our form, and they will deny whatever you submitted, even if it's completely legible on a piece of paper that is consistent with their form, raises the issues that they want you to raise. And there's specific things they allow you to appeal and certain things they don't allow you to appeal. And you have to comply with what's on the form. And even if you have things you want to raise beyond that, they won't consider anything other than what the form allows you to raise. And so in my situation, there isn't a claim on the form that you retaliated against me and you violated my due process rights. Well, even though I knew they weren't going to answer those, I wrote those on the form in addition to the other categories they had on the form, because if I didn't, when I got to federal court, they would say, well, you didn't raise this in the administrative process, even though there was no administrative process to raise it. So you have to go over and above what the process allows in order for you to not be knocked out of court later on. And many people don't know that either, and so they learn the hard way that, well, I did what the form told me to do. And the judge says, well, sorry, you didn't raise your federal constitutional claim in the form, and therefore you can't come into federal court.
So, I mean, this is just like a common sense, not based in anything else. But the way this is set up, it seems like it is intentionally designed to ensure or to make it as difficult and as opaque process as possible for individuals to be able to challenge their placement in solitary. Right? I mean, this doesn't seem like anything from a common sense standpoint that you're trying to actually ensure people are treated fairly.
Absolutely. Okay.
Yeah, I mean, if you're trying to design a system, I'm trying to think, if you're trying to design a system in which you had to have process, but you did not want to give any legitimacy to that process, this is how you would design it, right?
Correct.
Yeah. So once you have the form, you fill it out, you send it off, you have it written properly, you have all the contents and the substance as best you can. Somehow you know what your federal constitutional claims are, and you've identified all the administrative issues properly. Where does it go from there?
So, yeah, and I think I need to say a little bit more about that before we go where it goes from there.
There's more?
Yeah. So, I mean,
Mark, what is it supposed to, what?
Yeah, so the issues that you're going to raise, I mean, what?
Yeah.
I tried to present witnesses and they refused to let me present witnesses. I asked for an investigation. They refused to let me have an investigation. I asked for a polygraph. They refused to let me have a polygraph. I asked for to see the report alleging the charges against me.
This is all you put this all in the form. Request in the form.
So basically, what you're trying to have in a disciplinary process, if it's a real process, is due process rights, a meaningful opportunity to be heard and to defend yourself against the allegations. And at every turn, in my case, I was denied those things. And so I said I didn't have a meaningful opportunity to be heard. In reality, in every case, every prisoner is denied those things to varying
But
degrees.
let's pause there. So you fill out the form when what you're doing is requesting a bunch of things in order to be able to have a hearing or get prepared for a hearing or request a hearing in which you could present evidence, like you're saying, have witnesses, to be able to defend yourself, to say that the allegations against you and for the reasons you were placed in solitary or disciplinary seg were invalid, right? I mean, that's what you're asking for in that form.
Yeah, I mean, you're basically saying that the process you used against me denied me my ability to defend myself, and I guess your relief that you're asking for is a do-over so that you can have a hearing that gives you the meaningful opportunity to defend yourself,
Yeah.
which is never going to happen. And so
So,
that's what you have to kind of convey in the administrative review form is, hey, I was denied these things, and due process requires that I be allowed them.
so at the outset, when you're placed in disciplinary seg, is there a hearing or do they just give you a sanction and place you in disciplinary seg?
So sometimes you will be placed in segregation pending a hearing, and then other times you're out of segregation until after a hearing. But there's always going to be in a formal disciplinary process that's going to result in segregation time. There's always going to be an administrative hearing before a hearings officer. In my case, it was by video with a hearings officer at another location. I was locked in a cage. I was my hands were handcuffed behind me. I had documents that I wanted to share with the hearings officer. Those documents were placed on a table outside the cage where I was not able to access them. So, I mean, the whole process is just a sham from the beginning, right? And so, that's,
So,
typically how it's done.
yeah, so at that initial hearing, you're presented basically with allegations. You're able to defend yourself basically by verbal defense to whatever you.
Well, as you said, in your case, the allegations are, this is what the officer says you did. What's your defense?
Yeah.
And you're saying that's not true,
Yeah.
and it's your word against the officer's word. And so unless you're able to present some defense, and then you ask to do that, and they say, no, I'm not going to allow you to have witnesses. No, I'm not going to let you have an investigation. No, I'm not going to let you have a polygraph. Then how do you defend yourself?
So when you asked for all those things, just as a point of clarification, you asked it for all in that initial hearing. What you were saying is that initial hearing, before they placed you in disciplinary seg, I want an investigation. I have these documents that I can't access because I'm being handcuffed. I have witnesses that I could present that could, validate or affirm my innocence or undermine the allegations against me, right?
Mm-hmm.
And then they didn't let you have any of that stuff at that hearing, and then you were placed, found you guilty, sanctioned you, and then put you in segregation for the maximum amount. In your case, 120 days, right?
Correct. Correct.
And so then, yeah, sorry. So then I guess I jumped ahead because what I was then asking is when you're placed, you started talking about that appeals process or.
Correct.
Right?
Correct.
Okay.
So yeah, so then all the things related to the hearing would then go into this administrative review form.
Yeah.
There are other things related to segregation that you can't put in that administrative review form. For example, in my case, I found it highly offensive and just wrong that they deny you hygiene products for the first 30 days of segregation. So they're using hygiene products as a means of punishing prisoners. And so I wanted to raise an issue about that in federal court as well. But in order to do that, I had to pursue an administrative process for that as well. That couldn't go in the administrative review form, so that had to go in a grievance. Well, I filed the grievance and said that I was denied personal hygiene products as punishment for the first 30 days I was in segregation, toothpaste, shampoo, a washcloth, the basic things that you would have for basic hygiene and taking a shower or washing your face or whatever. And the grievance I submitted the grievance, and the grievance coordinator refused to process it and said, I am not allowed to grieve that. And what she said was, if there's a policy that says you have a right to hygiene, and an officer says, I'm not going to give it to you, you can grieve that. But if there's an unconstitutional policy that says you don't get to have hygiene, you're not allowed to grieve that. So it makes no sense, but that was their process. And so for me, for court purposes, okay, fine. Yeah, I tried to grieve it. You said you're not going to process my grievance. Therefore, I've done everything I can do, and I've exhausted all available administrative remedies. So that was done. But if in fact I were to file that grievance and then they respond to it saying, no, you weren't denied that, or whatever other reason, then I would have to appeal that up through the stages to higher levels of people within the Department of Corrections until at the third step, it would have been denied by somebody at the central office, an assistant director or something. And then at that point, that can go to court. And so there's all kinds of nuance to that process. So anyway, that was one thing off to the side. And then the disciplinary stuff, I finally got the disciplinary order from the superintendent, and I sat down to do the administrative review. And just based on my experience with the Department of Corrections, and so I guess I need to stop for a second. So you're in a cell, and this is a 2-page form, front and back, and you have then it was a pin that was about 3 inches long. My understanding is they've taken the pins away now, and they just give them golf pencils. And you're supposed to.
For people who don't play golf pencils are these.
They're like 2 or 3
inches pencil, yeah. They're like cut in half. If you played mini golf, you get them, yeah.
So that is your writing utensil, and you're in the cell without any, no legal research, you're not able to do anything other than write what your complaint is on this piece of paper. But my experience with the Department of Corrections was that I was going to keep a copy of that for myself, and I was going to get a copy of that to my attorneys. In fact, Julia is the one that I think I sent that to. So once I got my administrative review done within the 60-day time limit, very early within the 60-day time limit, in fact, like within days of receiving the superintendent's order, I put on the bars an envelope containing my administrative review request going to the Inspector General at the Department of Corrections, which is what you're told on the form you're supposed to do. And then another envelope containing the copy that I sent to Julia. And then I kept a copy in the cell for myself. And then I never heard another word about it. Never heard anything at all. And in addition to that, Julia and others here at OJRC tried some administrative process for me beyond that, that was also denied out of hand as soon as we made the request, without any consideration at all. And that was under a separate section in the rule that basically allows any prisoner to ask to have a disciplinary order vacated in the interest of justice for whatever reason you think it needs to be vacated, and there's no time limit on that.
That goes to the Inspector General.
And that goes to the Inspector General as well, yes. So anyway,
speaking of like the funny thing about mail, there was like a little issue with the mail with your one of your administrative reviews. I think.
Well, apparently
it was never received. And then all of a sudden, the day of your court hearing, it magically was received and had been lost in the mail. And, this is an interesting thing, because had you not done a contemporaneous copy and sent it to us referencing that, there would have been no evidence of the lost copy. I mean, and the judge made the fact that, yeah.
Yeah, I mean, you say lost, and we know better than that.
Yeah.
I mean, so basically, I submitted my administrative review request in September of 2021. And that, again, that administrative review request is absolutely necessary in order for you to go to court. There was no question in anybody within DOC's mind that I was going to federal court. I mean, I think they knew immediately I was going to federal court. And in fact, we filed the lawsuit in November of 2021. And yes, immediately the Department of Corrections attorneys moved to dismiss the case and try to kick me out of court by saying I did not exhaust my available administrative remedies. And then their position was I never filed an administrative review request. And of course, I said, yes, I did. Here's my copy. Here's my attorney's copy. I, in fact, did this. We had a hearing before federal court judge Michael Simon in early December of 2021, and those were at issue in that hearing. And the attorney general in that hearing was continuing to argue that I did not exhaust my administrative remedies. And thankfully, Judge Simon looked at the record and said, no, I believe he did exhaust his administrative remedies. And then, yeah, coincidentally, a few days after the hearing, they admit, oh, yeah, well, we got it. And we don't know what happened with the mail system, but it just got lost in the mail. And my belief is they absolutely intended to knock me out of court by saying I didn't exhaust my administrative remedies.
And the thing is that, but for your sort of skills and knowledge and capacity as like a legal assistant and someone being very, very thorough, and having the duplicate copies that you sent, one of them that you sent to us, they would have kicked you out. Like your case would have been dismissed. So, had it been someone else, someone with less capacity or not knowing, that would have been the end of it. Their case would have been over.
Yep.
So
all the time.
So we're starting to sort of fade into the federal stuff. So the administrative stuff, you had the hearing, you had the administrative sort of review of the hearing, all denied. We went to the inspector general through a separate pathway to review, just saying, look, this is silly. There's this pathway. We can go to the inspector general and say, look, in the interest of justice, you can just take a look at this in its totality and reverse all this. Inspector general didn't do anything, denied. And it was like a muddled letter that we got back that didn't make any sense, because they were admitting somehow that they had received the letter, even though they didn't receive the letter. They were like referencing to Julia, your administrative review, but not the inspector general. It was completely like, I would say like an incompetent kind of response back, but that's what it was, an administrative review process. So are we done with the administrative process? Nothing happened, right?
Yeah, nothing happened. I think we've covered everything that people need to understand about the administrative process. It's ridiculous.
So we have this internal review of the Department of Correction of your placement in solitary, or an AIC's placement in solitary. It's cumbersome, it's opaque, it's difficult, it's not meaningful. It's processed by definition in the sense there is a process you go through, but there's nothing meaningful or substantive about the process. So you had mentioned there's no vehicle to get into state court. So that means federal court is then the last place that you can go to. How many days has passed by the time you get you've initiated sort of your administrative review and processes to all the denials and stuff like that? Like, how long does that take?
Well, that's the thing. So if you're in an administrative process with a grievance, there's no control over that. You have these 14-day time limits on your end, but at each of the 3 steps, there's no time limit on prison officials. In my case, on the administrative review of the disciplinary sanction, I had 60 days to get it in. And like I say, I got it in as soon as I got the order from the superintendent. But the inspector general also has 60 days to respond to it. And so you have to wait a particular amount of time. I mean, you have to wait some amount of time for them to act on the administrative remedy. You can't just file it and jump into court. In our case, I filed that probably like September 20th. I went to segregation August 31st. We filed our lawsuit, I want to say November 21st. So we've already eaten up, 2.5, 3 months at this point. The hearing is like December 7th, and I get out of seg on December 31st.
So, I mean, in your instance, like you initiated all this administrative review process. You got sanctioned to the maximum amount, notwithstanding the upward departure. So 120 days, but you can be upward departed at previously up to 180 days. But you got like without the upward departure, the maximum 120 days. If you were sanctioned to like 60 days and you went through administrative review process, there's a possibility that you're out by the time the administrative review process is even finished, right?
Oh, it's more than a possibility. I mean, if you have a sanction of 60 days or less, I don't see that you're ever gonna be able to get a case filed in federal court. I mean,
Well,
not
I'm just talking
heard
about the
directly.
administrative remedies right now. So, like,
Well,
if
yeah,
you're
but
in for administrative review, let's say by some miracle the administrative review comes back favorable, but you've already done your time in SEG.
oh, absolutely.
Yeah.
Yeah, there's no way you're getting any relief at all.
What is the remedy at that point? Let's just say by some miracle you ended up being sanctioned for 30 days in segregation. You go through the administrative review process. It takes 60, 80, 90 days. And they say, oh, my bad. We're sorry. Like that was a mistake. But they already put you in segregation for 30 days. Is there a remedy at that point? They just take off the discipline? Is that it?
That would be all they would do and supposedly reinstate you. So there used to be a rule that they created years ago that said that if you have a disciplinary order vacated, that you are supposed to be reinstated to all the things you had within the prison system, your job, your incentive level, all the different things that you lost as a result of the disciplinary order. Well, they've deleted that rule, so they're not required to do that anymore. And so if by chance they said, oh yeah, you're right, you shouldn't have been found guilty of that misconduct, I guess the best you can hope for is that they're going to vacate the misconduct.
So
Even in vacating it, they still leave a record of it that you were convicted of it. And so when you go to a parole board later on, they see the charge and they're going, what was this all about? And you have to explain it even though you were exonerated essentially, you know.
and I mentioned all of this before we start into the federal court conversation, just to highlight, like there's not really an incentive or motivation for people not to put people in segregation. Like if you're a CO and you have some issues with someone, you sanction them, you can put them in disciplinary seg through this like kangaroo court process. They end up serving 30 to 45, 60 days, let's say. And let's say it's a vindictive corrections officer, or it's just someone that's just like very punitive. Worst case scenario, like what's going to happen? Like if the person's going to already have served that time, they get back out and they get the discipline off, or I mean, that's the remedy. So I just highlight the fact that um, there's not really any type of valid check on the system to act against the motivation or counter the motivation of systems that are like very punitive, right? Because I mean, there's no backlash at that point. I don't know.
No.
Yeah.
Well, there's really no backlash, even if you were to go into federal court and prevail in federal court, because there's the individuals that do the wrongdoing are insulated from the damage award is paid by the taxpayers. I mean, it's the state of Oregon
If you
pays
get there. Yeah.
if you're lucky to get there, which is very, very rare. But
So
if you get there, that nobody that did anything wrong is punished, is required to pay anything. I mean, so there's no incentive for them to do the right thing at any step in the process. No.
yeah, and all of the incentive and motivation is just to use this punishment that's available, right? Because if you're a corrections officer and you have this tool, you have the ability to remove someone from, the general population and put them in this restrictive housing unit or segregation for discipline, whatever, being vindictive, just being overly punitive. You had a bad day and the person's just annoying you. There's not like there's not any incentives not to use that.
No,
Or,
we've seen that happen a lot. Yeah, go ahead.
well, I was just gonna say, or as the Department of Corrections loves and public safety, quote unquote, people love, there's no deterrent.
No
There's,
deterrence. That's the word I've
there's,
been trying to.
yeah, there's nothing deterring them from actually doing it. It's
I
actually
was like, I knew there's a
incentive.
word, and I've been dancing around it, and I was like, God, what is this word? I can't recall what it is. Deterrence. That's what it is.
No, and we've seen so many times through the years where, take the bad day example you just gave, is like somebody comes in the unit and, there's a negative encounter between an officer and a prisoner, and the officer gets pissed off and decides he wants to make the inmate pay. He knows he can wreck everything about positive in his life by throwing him in segregation. And there's nobody that says, hey, you shouldn't have done that. And, you lose everything, just
Right.
because, this guy had a problem with you,
So, all right, so we talked about basically what I would call a sham process, this administrative review process. And for what it's worth, OJRC's been fighting for the past like several years, trying to open this up, trying to make legislative changes so people do have there's an immediate ability to get into court or to get some outside party to review any type of sanction and when someone's put into solitary for more than 15 days. And I'll let Zach kind of talk about that towards the end of the podcast today. But you've exhausted all this administrative remedy, and let's say for someone like you that was in for 120 days, you're still in solitary. You're now eligible because you've exhausted your administrative remedies to file in federal court. What are we filing in federal court at this point? Are you doing it yourself with an attorney? What's going on here?
So in my case, we filed a federal civil rights action and I was represented by OGRC attorneys Juan Chavez and Ben Hale. And I had a retaliation claim, but I also had a denial of due process claim. I was denied the witnesses and all that kind of the ability to defend myself, basically. And then that is where the next hurdle comes up that I was talking about with the Sandin decision is now the state is arguing that I can't bring a claim in federal court about my disciplinary process because 120 days is not an atypical and significant hardship. And then we have to argue about, well, why it is and what makes it atypical and what makes it significant and what makes it a hardship. And so then that's where a lot of the litigation plays out in federal court. And, the majority of those decisions fail for the prisoner. The Department of Corrections wins those because most federal judges find that the length of time or the conditions or whatever was not an atypical and significant hardship because of these decisions that say, that's something you should expect to suffer at some point,
So, I mean, just on that point, I mean, I asked you who you were represented by, and we knew you, we worked with you. Obviously, it's impossible to pinpoint why you're retaliated, what you're retaliated for, but like there are multiple things, including possibly your work with us, that contributed to the retaliation. But for a lot of people, they may not have an attorney or connected to an organization like ours. So are they filing these pro se? And I ask that also because one of the nice things about 1983s is that it gives the attorneys the abilities to collect awards at the end. But you just mentioned because these cases fail at such a high rate, there's not that possibility. So are most of the people who are filing in federal court, do they have attorneys or are they filing this stuff pro se?
It is very, very difficult to find attorneys who are willing to represent prisoners in federal court, largely because of the Prison Litigation Reform Act and all the barriers that it creates to bringing that kind of litigation, the way it limits damage awards, the way it limits attorney fees. It's very rare to get an attorney that's willing to handle a federal civil rights action. Usually it would be in cases of denial of medical care or prison sex abuse cases and things of that nature. Rarely have I seen attorneys represent prisoners in disciplinary cases. Prisoners obviously have no money to hire attorneys, so the attorneys would be required to do it typically on a contingency fee basis. That is, they agree that if you prevail in your suit, I'm going to take 30% of your damage award as my payment. Because of the unlikelihood of prevailing in these cases, and attorneys don't see that they would ever get paid and they would just be spending money to do this. On top of not having an attorney to represent them, so they are filing them pro se. These cases, I believe the filing fee now is $500. Not too many prisoners have that.
And can you get that waived in federal court?
No, they will look. You have to do a certified statement of your prison trust account. and other assets, and send a printout of your trust account statement, and the court will require you to pay a percentage of the $500 fee, and then on a monthly basis, they will automatically take money, pretty much the rest of the money in your trust account each month until it's paid off. I mean, when I say the rest of your money, it's basically if you have a prison job and you're getting, say, $50 a month, they're going to take $30 of it or $20 of it until that $500 filing fee is paid off. And typically, you've just paid that $500 filing fee to have a case dismissed. And so, that's something that people, I mean, as a legal assistant, I had a lot of people that came to me and said, I want to sue DOC for this, that, or the other thing. And I'm like, well, you got to understand, you're not going to get an attorney, and this is your filing fee, and they're going to come take the money, and you're ultimately probably going to lose this for these reasons. Do you really want to do this? And so a lot of people, some people say, yeah, I want to go through it anyway, but a large portion of people are like, yeah, that's just too much for me to be able to bear. So I'm going to just let this go then, I guess.
So just to like summarize or recap, you go through like this process where you're put into solitary. Most AICs would have, there's not clear information about how to be able to do administrative review, and how to be able to do it in a way that's meaningful to preserve all your issues for federal court. So already the door is like pretty much closing on you at that point. You get through the administrative review process and you're able to somehow miraculously like keep all your claims intact, and you've exhausted the administrative processes properly, and you're trying to get into federal court. Now you're butting up against financial sort of constraints, the inability to have an attorney, and you're going at this pro se. And these are not easy cases to be able to file. I mean, I know this is a lot of work that you would help with, but yeah, go ahead.
Yeah, let me stop you there with filing pro se, is that people don't know how to do that. So this is another layer of the problem, is that in 1977, the United States Supreme Court said that prisoners have a fundamental right to access the courts, and prison officials have an affirmative duty to assist them in filing meaningful legal papers. And they said that they can do that through the creation of a law library, or people that are trained in the law. DOC in Oregon decided to comply with that duty by creating kind of a hybrid of that process. And initially, that was providing law libraries and somewhat trained legal assistants. I was one of those. In 1995, however, again in the tough on crime era, the U.S. Supreme Court rolled back those rights a bit in Lewis v. Casey, and said prison officials don't have to give prisoners the ability to file anything and everything. They have to give them the ability to challenge their conviction and sentence, and they have to give them the ability to challenge the conditions of their confinement. And so that was my job as a legal assistant. As somebody came to me, if they had issues about their conviction or sentence, I was trying to help them navigate the court process to do that. If they had issues about discipline or medical or being raped in prison or whatever else about the conditions of their confinement, I was helping them navigate that. And typically, federal lawsuits are kind of your only way of navigating conditions of confinement. But my case was one of being retaliated against for doing that. That was the second time they had retaliated against me for helping fellow prisoners access the courts. The earlier time was in 2004 for again doing the same thing. And I mention that because the ripple effect of that is long-standing, both in the institution I'm in and throughout the Department of Corrections, in that it doesn't just affect me. The prisoners who come to me for help, or other people who want to serve in a role as a legal assistant, see what they did to me. And that's what DOC wants, is they want prisoners to see, if you do what he was doing, this is what's going to happen to you too. So make your decision about what you want to do as far as challenging DOC. And so what happens with that is you get people in the law libraries who are no longer trained, because Lewis v. Casey said you don't have to let them have training anymore. And so all you have to have is a high school diploma or a GED. You don't have to demonstrate that you have the ability to help anybody at all to get a job as a legal assistant. And once you get there, if you file suits against the Department of Corrections, well, you just might get retaliated against too. So most people say, well, I'm not going to help people file challenges against DOC. I'm just going to help them with their appeals. And so it's very difficult for someone who, again, can't read or write, has mental health issues, has language issues, who doesn't know what the hell to do to get a claim into court related to their discipline that was, erroneous, and they go to the law library, and those guys are either unable to help them or unwilling to help them for fear of going through the same kind of thing. And so it's another huge hurdle.
But then you have individuals filing these pro se, and let's by say some miracle, or let's say in your instance that you do have attorneys, you're filing it. What are the things that you're challenging at that point? I mean, is it the conditions of solitary? Is it the reasons why they placed you there? What are the legal claims you're trying to make at this point?
Sure.
Yeah.
In my case, it was the process that resulted in the disciplinary order, the inability to defend myself, but also the retaliation piece. So people can raise those kind of issues, but they could also raise conditions of confinement as well. The lack of hygiene, or whatever, lack of exercise, cold temperatures, combination of all of those and many other, conditions that make it cruel and unusual punishment, perhaps. If you're in federal court, you are raising federal constitutional claims. So those would be cruel and unusual punishment under the 8th Amendment. The process claims would be due process under the 14th Amendment. Those are kind of really the only kinds of claims you could really bring in federal court. State court, if you could bring state claims somewhere, there are some other things like unnecessary rigor under Article 1, Section 13 of the Oregon Constitution. But we have a cruel and unusual punishment here too. We don't have a due process in the state constitution.
Let me ask you, I mean, at this point, let's say you were serving 60 days and by the time you filed your federal lawsuit, you were already out of solitary. What are you asking the federal court to do at this point? Is it just to remove you from solitary? We mentioned damages. Like what are we asking the federal court to do at this point? And is it moot if you're taken out of solitary?
Well, I mean, that would be the state's argument that it is, but I would be arguing that disciplinary order that you put on me could result in me serving an additional 10 years or more in prison. It has long-reaching consequences, and
But that was just because of how your sentence was structured. There's some sentences that wouldn't impact like your length of stay, like if you're under a mandatory minimum or something.
Well, a disciplinary order will, in most instances, a disciplinary order in some form or fashion, even if you're not under a parole board process, will deny you good time credit that would have got you out of prison earlier than you were otherwise going to get out of prison because of the disciplinary orders. So there's always, or not always, there's oftentimes an impact on your stay in incarceration. It also impacts your conditions within the prison afterwards, because there's all.
And I just raised that not to say that there aren't those impacts, but it's just to say those impacts become highly individualized depending on the person's sentence and and how it's constructed and things like that.
Absolutely.
And just to say, like, also, like, to be able to articulate like the harms or the impacts it can be kind of complicated.
Absolutely.
Oh, sorry, go ahead. You were talking about like some of the other collateral impacts that
Yeah, I was just going to mention that you have the disciplinary hearing where there are in the rule, there are certain sanctions the hearings officer can give you that are the formal sanctions: segregation time, a loss of privileges, a fine, things of that nature. But the way the system is set up now in Oregon, at least, there a disciplinary order negatively impacts every aspect of a prisoner's life. It impacts their incentive level. I went from the highest incentive level within the prison system to the lowest incentive level. And at the time that happened, it would have taken me 18 months to get back to where I was in the beginning. And the incentive level is important because everything is attached to the incentive level. The type of jobs you can have, the amount of money you can earn, the type, how much visiting you can have, what type of visiting, what type of programs you can do, when you can go outside for recreation, how much money you can spend in the canteen, which impacts your ability to write your family and get hygiene products and access emails and video visits. I mean, it's just every aspect of life in prison is negatively impacted by a disciplinary order. And those do not have a process, so if you don't get rid of the disciplinary order and the formal sanctions, all these informal sanctions impact you for an extended period of time. As I said, for me at that time, it would have taken 18 months. Since then, when they reduced the seg time from 120 days to 60 days, largely because of the work OJRC has been doing to kind of push on this issue, they also decided, well, we need to increase the amount of other sanctions. And so we're going to make it even longer for you to get back up to the highest level again. And so now instead of 18 months, I believe it's like 3 years for somebody to actually make it from the bottom back to the top and have all these negative consequences that they suffer throughout that time. And then, of course, there's transfers and all this other stuff that happens as a result of this as well.
A lot of sleight of hand kind of things happening, you know?
Absolutely.
I mean, it's, I just find it so fascinating and disturbing that essentially the Department of Corrections as an institution, and I think as you said in one of the first podcasts that we had you on, you talked about how solitary is just solitary within solitary or isolation within isolation, that you have this institution that is able to put people in solitary kind of however it wants without any type of oversight or check. And the ability, for example, if you can make it into federal court and the federal court review at that point is very limited. If someone were to get damages, what kind of damages amount are we talking about? Have you seen? We're not talking like millions of dollars, right?
No. Well, I rarely see damages. I guess I was the lucky one, and that was $50,000. And so had they done the right thing at the administrative review process, they would have saved themselves they would have saved taxpayers $50,000 for doing what they did to me.
But most of the time,
that's pretty rare.
Yeah, most of the time, if you are getting damage, you're talking about single-digit $1,000.
I would assume less than 10,000 exactly. Yep.
So there's not like the monetary incentive for people because that's usually what the settlements do. It's like you get a huge award on a settlement in a federal case or, a jury verdict.
Behavior. Yep.
Yeah. And so DOC in the back of their mind or the actors in the back of their mind are saying, if we do this again, it's going to cost us millions of dollars. In this instance, again, there's no financial incentive or deterrence, the fancy word that Zach got me use, deterrence for people that way. So you have no check administrative review process, you have no state court remedy, you have no federal court really oversight. So you have a bunch of people who are just basically throwing people in cages without any oversight, check, or review of what's going on. This thing was like so disturbing to me when we started digging into this, because one of the things that the Department of Corrections tried to say, because while we don't encourage more law enforcement engagement or review of criminal behavior or anything like that, we were talking about the process and the need, like if individuals are committing new crimes, committing assaults, bringing in contraband, there should be outside law enforcement agencies actually investigating that potentially, right? And reviewing that to see if those are credible. But what DOC was saying is, we want to use solitary because it's a quick intervention. that we actually, if someone is committing a new crime, commits an assault, has contraband like drugs or whatever it is, we can scoop that up, sanction them, put them in disciplinary seg. And they admitted basically they are, and they don't involve OSP or the Oregon State Police, that it's faster and quicker, that they were admitting essentially the due process requirements, the procedural protections that exist in criminal cases were barriers, and they wanted to avoid that and just allow them the ability just to move quickly and put people in these horrific kind of environments or conditions as punishment. So to me, that was fascinating that they were admitting the fact that they found that the constitutional protections afforded to people in criminal cases were too much, or thought they were basically like it didn't allow them to move quick enough. So
Yeah.
All right, so we've gone through this whole process, and as I said at the beginning, essentially there's no oversight or check on the corrections officers. This is fair to say?
I think that's pretty fair to say.
All right. Zach, we've, as OJRC, introduced legislation in 2023 to try to address this issue. Do you want to talk a little bit about that? We called it what do we call it? The cause of action or something like that. We had our own sort of terms for it.
Rocket docket.
Rocket docket.
We had a rocket docket bill. We also had a solitary confinement bill.
But let's talk about the rocket docket first, because I think this goes to sort of the heart of what today's discussion, which is the lack of sort of outside checks on DOC.
Yeah, and you want what happened to it? I can give you the
what
spoiler alert.
Yeah, spoiler alert, it didn't pass. But what was the substance of the bill?
The substance of the bill was essentially giving some type of recourse through the courts for individuals who have received disciplinary action from the Department of Corrections, essentially trying to take it out of the Department of Corrections' hands for review and give it to the courts.
State courts.
The state courts, correct.
Yeah.
Which would, and the reason for rocket part of the docket is that it would, depending on, we had different versions that we were playing with, but we wanted to somehow get it so that it was going to be heard quickly by the state courts, either through a panel of judges, through Plan B judges, or even just a dedicated docket within the court system. We were kind of trying to work with the Oregon Judicial Department to figure out what would be most feasible and also the least expensive.
Yeah, and the idea was, if I recall, is like if someone was sanctioned to more than 15 days in solitary, they would have immediate access to be able to file something with the court for review, and the court
15 consecutive.
Yeah, and it would be on an expedited process, like you said. Like the review would have to happen within, like, I think 30 days. Hence, like you said, the rocket part of the docket. But
right.
Yeah, I mean, the idea is like let's get another branch of government involved, right? Like the legislature didn't seem or hasn't seemed interested in trying to provide legislative guidelines or mandates to the Department of Corrections in its use of solitary. So our thinking was, let's get the courts involved. Let's have some actors check, and it would have been a fact-finding court, like the ability for AICs to depose and develop a factual record in front of the judges. So it would have been like a robust check on DOC, and I think a strong deterrence against the abuse of solitary.
Right, because the complaints would see, or the reviews would see the light of day, versus everything being done within the halls of whatever prison they're being done in.
And within the prisons, the inability to develop a factual record for the AIC to develop a factual record. So yeah, you would have it out in a public filing, a court filing, the facts of what was going on. After this conversation, I think it's worth we try to bring it back up again.
Yeah, I think it's definitely, I mean, I think it's also worth maybe packaging it just together with the no more than 14 consecutive days in solitary. And then if you do get that, then you get the review.
Yeah, we'll have to think about that, because we are pushing for limited or more restrictive placement, like no more than 14 days.
Right. Arguable, if you could succeed on that, then I guess you don't need a review.
Well,
But
I think it's important that we mention why we're seeking that limit on 15, why we picked 15 as the number. I don't think we've really talked about that much at this
It's
point.
my favorite number, Mark.
Is it your favorite number? Well,
It is my
it's also
favorite.
not, it's
the
Nelson
United
Mandela's
Nations'
favorite number
favorite
as well.
number too,
Yeah.
apparently.
Why is 15 days like this number of days that we're looking at? It's not my favorite number. My favorite number is actually 11.
So the the United Nations and many other organizations, the World Health Organization, many national organizations, the American Bar Association, the National Correctional Health Care Commission, and on and on and on, have all said that due to the psychological impact of segregation that we see in 1890, the Supreme Court acknowledging, um, anything more than 15 days in solitary confinement constitutes the definition of torture. And so the United Nations has been the leader in limiting solitary confinement to no more than 15 days. Many states around the nation have gotten there at this point, but Oregon continues to resist efforts to do that.
And we should caveat, like the US is still a heavy practitioner of solitary confinement. I think the last numbers I heard, there's upwards of 80 to 100,000, maybe as many as 200,000 people on any given day
Yeah.
in solitary. So even though like some states have adjusted their use of solitary, it is this sleight of hand that's still being used by corrections where, they reduce with one, but they make it easier to put you in ADSEG or IMU or, other forms of solitary. So it's not just, I just want to highlight like,
No, I agree with that. And I would say that it's exactly what I was talking about. Yeah, I think the first podcast where, previously there was no limit at all on disciplinary segregation in Oregon, and the federal court said you can't do that. So then they capped it at 180 days, but then created this intensive management unit that's not capped that allowed them to do that. And I agree that a lot of these states that claim to be complying with this, it's called the Mandela rules from Nelson Mandela that the United Nations put out, and that a lot of states are claiming that they're complying with the Mandela rules by reducing their disciplinary segregation. But in doing that, like Bobbin said, they are increasing these other forms of solitary confinement while they point everybody to the stats of their disciplinary segregation being reduced. And so it continues to be just, whack-a-mole, I mean, every time you get them confined to do the right thing, they find a way to weasel out of it.
Which is why it's important when we discuss, what we want our proposed legislation to look like. One of the important considerations is do you even, if you give a label, right? So if you say, no use of disciplinary segregation, then they're just going to use it for administrative purposes that serve effectively as disciplinary purposes. And so one of the things we've learned is potentially using, no more than 15 days keeping someone and then the time in cell as the trigger for it instead of saying solitary or saying segregate because it's a shell game, as I think Bobbin you said earlier, but trying to figure out a way in which we can lock them into, you just cannot lock people away for more than 14 hours a day for more than 15 days in a row, something to that effect that doesn't allow them out of it.
isn't that interesting and also disturbing that in order to be able to talk about this issue, we have to be descriptive as to the actual behavior? We can't just use the term. We have to actually say these things. Like you cannot put another human in this environment for a period of time, and be very clear about that. Because if we don't, they will. Like, I mean, it's very sad and disturbing that this is where we're at, that, they will continue to find ways to put people in these conditions.
Well, just like I mentioned in the first podcast, I mean, it's just all this disingenuous talk by the prison officials where, they'll stand in front of the disciplinary segregation unit saying we don't have solitary confinement in Oregon.
Mm-hmm.
And, so unless you're able to address every aspect like Zach's saying, they're going to find a way to keep doing it.
So, I mean, I have to believe that most individuals, when they hear about the kind of things that you and Kyle Black and Julia have talked about as what they've seen, and Zach as far as like solitary, how people are treated, that they would be horrified by it, that they would have like just a natural, the instinct would be to say this is inappropriate.
I
Uh,
hope so.
just as we wrap up, I mean, so what are your thoughts, each of you, as far as like what is the barriers that we're facing in being able to get people to understand that this is an inappropriate, this should be inappropriate, this should not be allowed. Um, I mean, what is it what is the disconnect that exists?
Julia?
We don't know. I feel like we ask ourselves this all the time when it comes to all sorts of things in the criminal justice system, and then especially when it comes to prison conditions. I do think it takes an effort to get people there, even just intellectually, and then to get people there to like really feel what that would mean. I think that's challenging for folks. And this is a population that people don't see, don't think about on a regular basis. And when it comes to the legislators, I think that there is just a very loud voice in opposition of thinking about people who commit crimes or who are in prison as human beings. There's just so much in the oppositional camp about, that's fear-based, that's about any sort of consideration that we treat individuals who are in prison or have committed crimes with some sense of humanity. The automatic reaction to that is somehow this impacts public safety and this is not considerate of victims. And that's sort of where legislators and lawmakers, I think that's the easy default to just defer to that without having to, and it's also just easier than having to really take a look at what we've been doing. And we've just been doing it for so long that people are just so normalized to it.
Yeah, I mean, the reason we've been doing it for so long is because it's the American way, not just the Oregon way, but the American way. And, no offense to Americans, but this is a
Oh, you should be completely offended.
yeah, they should definitely be offended. We should all be offended. And we are offended. But many people are shamelessly not offended. I think that I talk about this all the time, this punitive nature of Americans, this desire to see people hurting, punished, you know. Um, I just think it's, in a lot of other aspects, there's discussions about whether, negative reinforcement or positive reinforcement is more conducive to positive outcomes, for example. But then that stops at the prison wall, right? Where they're like, you know what? We have all this research showing that positive reinforcement is significantly more impactful and more successful. But you know what? Let's use negative reinforcement. And then when they want to use positive reinforcement and they want to say they're using it, they do it in a way that completely just incentivizes only like necessary items, right? So it's like, let's strip everyone of even more stuff and then give them the ability to build it back up through positive reinforcement, which is not at all the way that it should be done. So I think it's an ethos. I think it's an American ethos. I think Julia also hit it right on the head, which is that any sort of human treatment or even God forbid, compassion towards people who are incarcerated, mainly because we want to see people who are in, not be tortured, but also those who come out and be more successful. There is this sense that if you do show that compassion, you do show that understanding of what will make someone a better person when they get out, or even while they're in, that it's somehow anti-victim, and that it's somehow soft on crime, which is just, you have to really stretch common sense to get there, and I think plenty of people are willing to do that. Yeah.
I would echo what Julia and Zach both said. Is that, I mean, as I pointed out at the beginning here, I mean, we've had solitary confinement since we've had our first American prison, and we've known that it's harmful since then. Part of the disconnect, I think, is the whole idea that prisons are out of sight, out of mind. They're not my problem. I don't want to know what goes on there. And as long as people take that approach, as long as people do not pay attention to what's going on in the prisons, this kind of stuff happens. That's why prison officials do resist our efforts to get this outside scrutiny of what they're doing. They hate outside scrutiny because it will limit ultimately what they are allowed to do within the prison system. And then, within the prison system, and honestly, I think people who think about the prison system and prisoners, it is this, as Zach was suggesting, it's this belief that they are bad or evil people who deserve to be punished. And honestly, a lot of people think they're not even people, that they are animals. There's a dehumanization that goes on in how we think about and how we talk about prisoners, and what they deserve. They should be raped in the shower. Those are the jokes, all this different stuff that says that this is okay, and we don't care about it. And then as you all alluded to, is like, I mean, I'm really frustrated with our elected officials who, even in my case, there was one lawmaker who called a legislative hearing on this thing, and DOC rallied the victims and claimed that what they were doing was in the interest of victims, and that shut down that process that they intended to have before we had it. I mean, I think far too many times lawmakers are still afraid that they will look soft on crime. It's not about soft on crime and tough on crime. It's about being smart on crime. And it's like Zach said, we want people to get out and succeed. But what that means to the people who are listening to this, we want people to get out and not commit crimes against you and your neighbors. We want them to be healthy, contributing members of society. And if you treat them like a dog in a cage in prison, you're going to get somebody outside prison who is still really angry and is still is more broken by the process than they went in. And so you're not serving your own interests when you're advocating that they be treated like this in prison. And so it's a combination of all of this stuff. And I mean, sadly, like Zach says, I fear that it is who we are as Americans and how we feel about punishment. That rehabilitation is something that we've given up on, and it's just really sad. But it makes me feel like, you're going to hear 100 years from now that this is still a problem.
I would just add one other quick piece. A tangible, real obstacle also is the unions that represent the correctional officers. The correctional officers, I think at large, think positively on the use of solitary confinement. Gives them they don't care whether it's right or wrong, whether it's due process or not, whether they're just taking it out on someone. They do generally believe it's a tool, and they don't want that tool taken away. And so any sort of conversation really does come to a halt and have to really work around correctional officers. And one would just hope that correctional officers would be willing to learn that there are better ways in which to do it, in which to rehabilitate, in which to impart learning lessons upon adults in custody. They don't seem to care right now, but that's a big impediment for us.
I mean, there is a monetary side to this that sort of is an undercurrent as far as like the motivations and incentives that exist for keeping these systems in place. But just to wrap up, I mean, I think like you said, Mark, it's not about I wouldn't even use the term smart on crime. I think it's just about how do we be thoughtful in treating the people in our community? Like, what is the appropriate way to treat people? And this is not it. It goes back to a cultural aspect, I think, Zach, that you mentioned, and some of the tensions and dynamics at play that Julia mentioned, as far as like fear-based politics and people being perceived as being soft on crime, but just this overall sort of value system that kind of is persistent since the inception of this country, which is to dominate and control and punish, right? Like that's how this country was founded, by dominating, controlling populations, removing populations. It's a value system that sort of underlays. And part of why I think this is so important for us to change this here in Oregon and to say this is not okay, and to get elected leaders and public officials to understand that this shouldn't be okay, is because once we say this is not okay, and we can begin to reorient this value system at this most fundamental level, it begins us to being able to reorient the value system at a higher level. We have to lift the floor up before we can expect some better treatment of people out in the community, and healthcare and education and other social services and things like that. But so long as we allow some of these things to persist, it doesn't allow us to, I think, raise and reorient the value systems at a higher level. But I just want to thank you all for the conversations on solitary. The next solitary conversations that we're going to have, we'll have two more. One that will focus on solitary at OIA, which we'll have our Youth Justice Project team be involved in. But I think the next conversation we're going to have is we'll have Ben Hale and Mark come back, and Ben to join us to talk about the social science around solitary and the impacts. We've alluded to it a lot and referred to it, but both Mark and Ben have done like a deep dive into the social science based on some of the litigation that we've forwarded, and have like a really good understanding of what the social science is telling us. So that'll be solitary part 4, hopefully coming up in the next couple weeks. Thank you all for listening to another episode of Trailblazing Justice. We'll be back with another episode soon.